Okay, welcome everyone. I'm Singh-Knights, professor with WVU Extension Service as a specialist in agricultural economics and management. I'm co-project director for this project, and it's titled Landowner Rights and Responsibilities in West Virginia. And it's supported by the Northeast Extension Risk Management Education Center. As part of this grant, today we have a presentation focusing on issues related to landowner rights and responsibilities in West Virginia. Our speaker today is Jesse Richardson. Jesse Richardson is the Hall and Roscoe Poston Professor of Law and Land Use, or Lead Land Use Attorney rather, at the Land Use and Sustainable Developmental Law Clinic at West Virginia University's College of Law. Before coming to West Virginia University, Professor Richardson was an associate professor in urban affairs and planning at Virginia Tech. He holds a BS and MS in agricultural and applied economics from Virginia Tech and a JD from the University of Virginia School of Law. He began his legal career in private practice in his hometown of Winchester, Virginia. His research and experience focus on energy law, agricultural law, land use law, and water law. Professor Richardson previously served on the board of directors of the American Agricultural Law Association, including stints as president-elect and president of that organization. So I'll hand you over to Jesse Richardson. Take it away, Jesse.
Thanks, Dee. I appreciate it. And hello, everyone. I'm happy to talk to you today about our Landowner Rights and Responsibilities project. Note that the presentation today is not going to cover everything. We have a manual coming out, and it will be available on the web, on the internet, and it will be more comprehensive, but even that manual is just providing a brief overview and summary of the major landowner rights and responsibilities in West Virginia. The manual will be intended to give you a starting point and give you some references to look at and something that you can use when you talk to an attorney or talk to other resources. And this material is based on work supported by the United States Department of Agriculture, National Institute of Food and Agriculture, under award number 2023-700027-40447 that we received from the Northeast Extension Risk Management Education. And we really appreciate that. In addition to thanking Northeast Risk Management Education, USDA, and NIFA, I also have to thank our stakeholder committee that I'll show you that list in a minute. West Virginia Cooperative Extension, the West Virginia Farm Bureau, the Mercer County Farm Bureau, and this is where that project really started, with Dennis Richmond and the Mercer County Farm Bureau, the West Virginia Department of Agriculture, and my two research assistants, Claudia Medja and Megan Skeen, who helped me put this together. And here's our stakeholder committee. I'll let you take a look at that. These are farmers, producers, and agricultural industry representatives from across the state who provided valuable input into this project. And then within West Virginia Cooperative Extension, I have to particularly thank Dee, who you've already met, Jody Richmond, Alex Smith, and Debbie Friend. Jody, Alex, and Debbie hosted workshops across the state and also helped with evaluations and putting everything together. Nothing in this presentation is legal advice. I don't know the particular circumstances of your situation, and so I can't give you any legal advice. This is for educational purposes only, to put out some information. You should seek legal advice, talk to an attorney to apply these general legal principles to your specific situation. So with that preliminary information over, let's get into a little of the meat and potatoes here. So one thing is to give you an overview of a lawsuit and how liability and responsibility works generally and how it works specifically in West Virginia. Lawsuits, anybody can sue anybody for anything in the United States, but to have a successful lawsuit, we're going to talk about some elements a little later in the presentation. We're going to talk about the fact that there has to be a duty of care. And for landowners, there's one duty of care for trespassers and another for non-trespassers. And then we're going to go really quickly through some of the liability responsibility laws in West Virginia. And then at the end, talk about some conclusions and what your next steps might be. So this booklet was originally written in 1979. It was updated in 1997, but that 1979 version was still the version that was generally being circulated within the state. And since 1979, of course, and even since 1997, that's over 25 years ago, there have been a lot of changes in the law. And the updates that we're finalizing right now, and that should be done this fall, are extensive. We rewrote a lot of the sections. We added several sections based on our stakeholder committee input and the work of a cooperative extension. We made a lot of changes. In addition to the workshops in Mercer and Hardy County, we did a workshop in Braxton County due to the high demand that we had for the workshops. And now we're doing this video because we just think that there's been a lot of demand for this and we want to get the information out and make it available. And like I said before, this project intends to give everyone a basic, very basic understanding of what rights a landowner has in the use of property and what duties the landowner has. Not only are there rights, but there are responsibilities. And those responsibilities go to neighbors, to strangers, and to the government. And there are certain governmental rights that are superior to or supersede the rights of the landowner. And again, to serve as a reference guide for people who are trying to start their research on these issues. Now, when we looked at this, there are several thousand laws that apply to landowners, which is pretty overwhelming. We obviously can't go over each and every one of those laws. So we're going to, and the ones that we go over, we can't go over in a lot of depth. We're going to provide some brief summaries. Each situation is different, and the law is very fact specific. So you should not take anything in this booklet as legal advice. And you should not take anything in this booklet to say, well, this means definitely in my situation, it means X. You should talk to an attorney about that. So some legal basics, and I think this is really important to understand landowner rights and responsibilities. Although anybody can sue anybody for anything in the United States, a successful lawsuit counts on having four things. First, the person that you are seeking to hold responsible, we call them the defendant, they must have a duty. And so when we're talking today, we're going to be talking mainly about what legal duties does a landowner have to others or to the government or the like. And we'll talk pretty early on about duties to trespassers and duties to non-trespassers. But let's just use it as an example. If you invite somebody onto your property or you have a business where people come onto your property, you have a duty to take reasonable care to protect those people. And we'll talk about that more a little later. The second element of a successful lawsuit is that the defendant must breach that duty. So in the instance of a landowner and somebody who is invited to come on their property, if the landowner did not use reasonable care, then they have breached their duty. The third and fourth steps kind of go together. The breach of that duty must have caused the injured party, that we call the plaintiff, damages. So one of those factors is causation. Did the breach of the duty actually cause some damages? And second, there has to be some actual damages. The law is kind of like the playground, no harm, no foul. So you have to be able to show some damages. And we're also going to be talking about civil law on the one hand and criminal law. For example, we're going to talk about trespass. There's civil trespass and there's criminal trespass. For civil law, the remedies are damages, which are generally compensatory damages to compensate the victim, to pay for injuries, emotional distress, and the like. And in very rare circumstances, the plaintiff can ask for and receive punitive damages that are meant to punish the wrongdoer and to discourage that behavior from happening in the future. Also, in a civil lawsuit, the plaintiff may get injunctive relief. And injunctive relief means that the judge or the court will say, defendant, you cannot emit smoke anymore, or you cannot do certain things on your property. Or the court may say, defendant, you must restore that wetland, or you must take these certain steps. In criminal law, on the other hand, that's where the state or federal government, or sometimes the local government, proceeds against an individual or a business for violating criminal laws that we have in our society, that we have said, for example, that thou shalt not kill another person, except in some really limited circumstances, self-defense and the like. If you violate a criminal statute, the state or local or federal government will prosecute a case against you and will ask for fines or incarceration. Like I said, we'll talk about that a little more later. Throughout the publication, we will talk about some federal laws and some state laws. There are 55 counties in West Virginia and well over 100 municipalities, several hundred municipalities. We cannot go into detail at all or talk about local regulations. There are just too many. So be mindful that you should always check with your local government. That may be the local zoning and planning, the local health department, or other local agencies, to see if there are local laws that might impact you. In general, municipalities are going to have more regulations than counties, but you should check it out in both instances. And related to that, in West Virginia, as in all of the 50 states, we have a law that we call the Right to Farm Act. And I wanted to give you a little bit of an overview of the Right to Farm Act before we start with trespass. West Virginia's Right to Farm Act in every state is a little different. West Virginia's Right to Farm Act prohibits counties from passing ordinances or rules that are stricter than or contravene any state rule pertaining to agricultural operations. Now, what that exactly means is unclear, but the main point is that local counties, and I should say this does not apply to municipalities, counties in West Virginia are restricted from regulating agriculture any more strictly than the state does. So that's something that you should keep in mind. In addition, counties may not regulate pesticides, herbicides, or insecticides in any way. Those are two things to keep in mind as we talk further. Trespass, important issue. And there is civil trespass and criminal trespass. Civil trespass is an intentional or negligent entry onto another's real property without lawful authority and doing some damage. And that could include an ultra-hazardous activity like blasting that causes materials to trespass. Criminal, on the other hand, and note that first word, willful. If it's civil, it has to be intentional or negligent. There's a higher standard for criminal. It has to be willful, unauthorized entry upon, in, or under the property of another. And there are some exceptions for government employees and the like. The criminal law separates different types of trespass. If it's in a structure, the penalties are more strict than if it is in an open field, for example. And then the penalties are even more strict if the trespass is in a structure like a house or barn, and the trespasser has a firearm. So look at the differences in civil and criminal and the differences in the various types of criminal. The booklet will detail these more. And next, we're going to talk about posting. And I want to call attention again. Civil means intentional or negligent entry. Criminal has to be willful. That's important. In additional, civil trespass has to cause some damages. Most civil trespasses do not cause damage. Now, if you tear down a fence or something like that, yes. But merely walking on somebody's property is not going to cause damages. And that, in my opinion, is one reason why we have our civil or criminal penalties. And to make sure that that trespass is willful, posting the property is very important, because once you post the property, any trespass is going to be willful if you post it according to the law. Two different ways to do that. First is by signage. If you use signage, the signs must be separated by not more than 500 feet along the boundary. You must have a sign at each corner. You must have a sign at all roads, driveways, and gates of entry. The sign must say no trespassing, and the letters must be at least 2 inches high. Very particular. Note that if you have enclosed or fenced in land of not more than 5 acres where there is a dwelling, you do not need to post the property. That is deemed to be posted. In addition, if you have fenced or cultivated lands, that is deemed to be posted, and you don't legally have to have signage. You don't legally have to have it, but the signage is not going to hurt. Now, a fairly recent innovation in the law is that you can post with purple paint markings. Very particular requirements for purple paint. It has to be at least one vertical line, not less than 8 inches long and 2 inches wide. The bottom of the marking cannot be less than 3 feet nor more than 6 feet from the ground or normal water surface. The purple marking must be affixed to immovable, permanent objects no more than 100 feet apart and readily visible by anyone approaching the property. Generally, the purple markings are going to be on trees or fence posts or something of that nature. And even if you use purple markings, you still have to have written signs on all roads, driveways, and gates of entry. There are more particular rules for trespass on hunting. You can use signage or purple painted markings. It is a criminal violation to shoot, hunt, trap, or fish on any posted, fenced, or cultivated land. It's illegal to peel trees or timber. It is unlawful to build fires without permission. And it is a criminal offense to discharge a firearm within 500 feet of a dwelling, school, or church, or across a public road or municipal park, or within a municipal park or public road. So that covers the basics of trespassing. Our next topic is very important. Lawyers call the liability law surrounding property owners premises liability. So if you own property, we call it premises. You own any property in West Virginia or anywhere, you are liable in certain circumstances. We have broken down the types of people that might come onto your property in 3 different categories. The first category is a trespasser, and we just talked about that. They come onto your property without permission or invitation of any type. So let's use a hypothetical. And the booklet has a number of hypotheticals, and we're not going to go over all of them today, but the hypotheticals help illustrate the principles. So the first hypothetical, Z sets up a spring gun to fire rock salt at someone who attempts to break into a building. So maybe there have been a string of break-ins. The landowner is fed up, and so they set up a spring gun. When somebody opens the door, the gun will fire and shoot rock salt, maybe at their knees or something like that. Not intended to kill anyone, just to deter them from breaking into the property. X attempts to break in and is injured. Is Z liable for that? Think about that for a minute. Can you do this? The second thing to think about is children. What is your duty to trespassing children? Now, a lot of people I talk to say the children's parents should take care of the children. Be that as it may, in West Virginia and in other states, you have a duty to trespassers and you have a duty to children. What is that duty? For trespassers, you have a duty not to willfully and wantonly injure the trespasser. No spring guns. You cannot set up booby traps. You cannot set up things that might injure somebody who is trespassing. That's your only duty. You don't have a duty to make things safe. You just have a duty not to intentionally injure somebody, even if they're a trespasser. And some people seem to be surprised by that, but you do have a duty to trespassers. How about children? That is a tough one. Children on your property, if you know that children are going to be on your property, or you should know that children are going to be on your property, you have a duty not to maintain a dangerous instrumentality. What is that? A dangerous instrumentality is where the landowner knows or should know that it's attractive to children, it is likely to bring children onto the property, and is likely to be injurious. Now, things like a rope swing or even just a pond might be a dangerous instrumentality. The law in West Virginia is a little more favorable to landowners than the law in a lot of states, but it's still something to be concerned about. A rope swing or a pond in West Virginia is not necessarily a dangerous instrumentality, but it might be if there is a hidden danger. So if that rope on the rope swing is cut or is frayed, maybe that's a dangerous instrumentality. If the rope is attached to a broken limb or a very small limb, maybe a dangerous instrumentality. Farm pond, a normal farm pond is not a dangerous instrumentality, but let's say there's a really steep drop off in the pond. That may make it a dangerous instrumentality. Again, I think you should use caution here and try to make sure that your property is relatively safe, even for the trespasser, and especially if that trespasser is a child. How about other than trespassers? We've called people who are customers, they are invitees. People who are social guests are licensees. In some states, a different duty is owed to each of those types of visitors. In West Virginia, we have collapsed the two, and the same duty is owed to a licensee and to an invitee. That duty is a duty of reasonable care under the circumstances. What does that mean? Well, the West Virginia Supreme Court has attempted to clear that up a little bit. And they said, when you're looking at the duty of reasonable care under the circumstances, look at how foreseeable is it that the injury might occur? How severe would the injury be? What are the time, manner, and circumstances under which the injured party entered the premises? What is the normal and expected use of the premises? And what's the magnitude of the burden placed upon the landowner to guard against the injury? That doesn't really clarify much, does it? Still a lot of question marks. So this presentation, this booklet, this project is not focused on insurance or minimizing liability. However, there are resources at West Virginia Cooperative Extension that talk about minimizing liability, and in particular, liability insurance. And I urge you to check out those resources to make sure that you're protected against this type of liability. There's also a doctrine called the open and obvious doctrine that applies to invitees and licensees. And that says that a landowner does not have a duty of care to protect other people against dangers that are open, obvious, reasonably apparent, or as well known to that other person as they are to the owner of the property. Again, what is open and obvious is kind of unclear, but I would suggest that if it's something that everybody can see, it's a big, I want to say a big hole in the ground, but they can be kind of hidden. But if it's something very large and visible that everybody can see, you don't have a duty to protect people against that. Again, you don't have a duty, but if it goes to court, there's going to be a lot of question marks and it's going to be costly. So if you can, I would still try to use orange cones or markings or fence or something to try to go that extra mile to protect yourself from liability. But if push comes to shove, you have the open and obvious doctrine. Many states, including West Virginia, also protect owners of property who allow other people to use their property for recreational uses. And the basically says that these people that you allow to come on your property to engage in recreational or wildlife propagation purposes, you are allowed to treat them like trespassers. So your only duty is to not willfully and wantonly injure them. You do not have to keep the premises safe. You do not have to warn them of hazardous conditions, anything of that nature. You do not extend any assurance that the property is safe. They are not invitees or licensees. They are treated by the law as trespassers. And they assume responsibility for any injury that is caused by that person, that trespasser under the law, who did something wrong, basically. But you are responsible if you deliberately, willfully, or maliciously injure those people on your property. To get this protection, you cannot charge a fee of more than $50 per year per person. If you charge more than $50 per year per person for that recreational use on the property, they become invitees. And you owe that duty of reasonable care under the circumstances. Now, recreational use under this statute is very, very broad. Fishing, hunting, swimming, boating, camping, motorcycles, spelunking for you cavers, water skiing, archaeological, scenic, or scientific sites, aircraft, even ultralight. So a very broad category of recreational uses are covered. So this is great, right? You don't need liability insurance, do you? Yes, you still need liability insurance. So again, I'm not going to go into this in depth, but even if you have the protection of the recreational use statute, yes, get that liability insurance. A similar type statute in West Virginia and many other states is the Agritourism Responsibility Act. And that applies to agritourism operators. They are not liable for injury or death of a participant or property damage as the result of the inherent risk of the property, of the activity, I'm sorry. To get that liability protection, you have to post a notice, and the notice has very specific requirements as to what it has to say, how big the print has to be, all of that type of thing. So check that out. And if you are grossly negligent or willfully or wantonly disregard the safety of another or intentionally harm somebody, you are still liable. The participants must act reasonably. That's why it calls it the Agritourism Responsibility Act. It places some responsibility on the participant. Again, this is what the law sets as a minimum. I recommend that to the extent that you can, do a little more. Make your property safe for those participants. It's great that you have the Agritourism Responsibility Act, but I would use it more as a backup than trying to primarily rely on that. And yes, you still need liability insurance. Let's move on to a different topic. In addition to trespass, nuisance is another type of potential liability for landowner. A nuisance is anything that interferes with the rights of a citizen in their person, property, or enjoyment of property. So that could be something that causes noise, smoke, odors, things of that nature. That sounds like agriculture, right? The conduct must be intentional and unreasonable. And by that, we don't mean that you want to intentionally harm somebody. It means that you are intentionally plowing the field or doing that activity. Might be negligent or reckless. It results in abnormally dangerous condition or activities in an inappropriate place. So it looks at where are you? Are there houses? Is there housing subdivision nearby? Could be noise, odors, unsanitary condition, or just any incompatible use of the land. Public nuisances are often criminal offenses, and public nuisances include things like crack houses or things of that nature that affect the public at large. So let's look at an agricultural hypothetical here. Z farms his homestead property. X acquired and occupied the neighboring property after Z had been farming for 5 years. X now complains about the odors and noise from Z's farm. Let's assume that Z is using best farming practices. Does X have a valid nuisance claim against Z? Given what we just talked about, it sure sounds like it, doesn't it? But that Right to Farm Act comes into play again. And the state has said agriculture is not adverse to the use of adjoining property. And if you want to file a complaint, if X wants to file a complaint here, the complaining party must have begun using and occupying the property before the agricultural operation. The conduct of the agricultural operation has caused or will cause actual physical damage to the person or property of the complaining party. Now, the owner or operator of the farm is not excused of any other legal duties, but they are protected against these nuisances. So think back to our hypothetical. The answer here is no. That is not a nuisance because the right to farm says since X moved to the property after Z had already been farming for 5 years, Z has a valid defense to the nuisance claim. I'm going to sound like a broken record, but I would still recommend that you use that Right to Farm Act as a backstop, but don't rely on it 100%. It's always better to have good relationships with the neighbors, but the Right to Farm Act will come in and protect you in certain situations. Shifting to animals. Let's start with dogs. Most of you probably know this. A dog has to be registered and the owner of the dog has to pay a head tax. Dog owners are liable for all damages caused by the dog while running loose. If a dog chases and kills livestock or chickens, that dog must be euthanized. The livestock owner can also kill a dog that is actively chasing livestock. And that, to bring in something here from the law, a dog is personal property. And I know a lot of us are attached to our dogs. When they're considered personal property, a livestock is personal property. So you can destroy personal property to protect personal property. That's why the farmer can shoot that dog that's chasing the livestock. However, outside of those types of circumstances, dogs and other pets are protected and may not be harmed. So you can't just go out and shoot barn cats for fun. And you can't harm or kill animals unless you have a very valid reason that animal is threatening one of your animals or threatening another person. X's dog is frequently allowed to run loose, and Z often sees the dog on their property. The dog doesn't do any damage to Z or Z's property, but Z just wants the dog to stay away. What can Z do? Again, in this situation, Z can't shoot the dog. You can't shoot a dog or a human for trespassing. The dog's not chasing livestock. So Z can ask X to tie the dog or confine the dog. If that doesn't work, Z should contact the county dog warden. Dogs are also protected if they're licensed from stealing, injuring, or killing by someone not the owner. If someone does that, they're guilty of a misdemeanor, and they might have to do public service or receive a fine. A dog is considered to run at large if it is not properly secured. What if X's dog does damage to Z, his property, and the dog is threatening to Z's child? What can Z do? Well, in this case, Z can lawfully kill the dog if Z sees the dog chasing, worrying, or wounding livestock or endangering the life of a human. And the dog owner is liable for damages that the dog inflicts to the livestock or to other humans. So keep that in mind if you're a dog owner. How about livestock? Livestock includes cattle, horses, pigs, sheep, goats, whole range of different animals. A landowner must report livestock running at large. So again, you can't say, wow, there's a cow running loose, I'm going to shoot the cow. You can't do that. Can't harm the cow. You need to report them. You are allowed to contain them. You can charge reasonable charges for containment, but do not harm them. Malicious injury to livestock is a criminal offense. Additionally, a owner of livestock has a duty to report if one of their livestock has a communicable disease. They must report that information to the West Virginia Department of Agriculture. Failure to report is a crime. And if one of your diseased animals dies, the owner must properly dispose of the carcass. This is to protect other people and other livestock from those diseases. I mean, I don't have to say much more than the avian flu, and you'll understand that this is to protect everybody. What if Z finds some rabbits or cows or other animals damaging crops, but they can't identify who the animal belongs to? And what if they identify the owner, but the owner never responds? Under West Virginia law, if the owner of trespassing livestock cannot be identified, or the owner does not recover the livestock within 10 days of being notified, the county sheriff takes possession of the animals. The sheriff may attempt to return the livestock to the owner, and the sheriff may also seek reimbursement for containment. What if returning the livestock is not possible? If returning the livestock is not possible, the sheriff will auction off the livestock at public auction, and whatever is received will go to the cost, and if anything is left over, to the owner. Okay, now let's talk about endangered species. And this is some federal law. West Virginia is home to 22 endangered species, 19 animals, and 3 plants, and 7 threatened species. Section 9 of the Endangered Species Act prohibits the taking of an endangered or threatened species. And taking is very broad. It means harassing, harming, hunting, shooting, wounding, or attempting to do any of this. Now, as of today, and this is something that the federal government is looking at right now, but as of today, in destroying endangered species habitat is a take of an endangered species. And if you take an endangered species, the civil penalties are up to $25,000 per violation, criminal fines of up to $50,000 per violation, and imprisonment of up to 1 year per violation. Serious penalties. So if you are wondering whether there are endangered species on your property, you should contact the director of West Virginia Division of Natural Resources. I'll also mention that under the Endangered Species Act, there are some programs that if you want to help conserve the endangered species and take certain steps, the federal government will allow you to kill or take endangered species, incidental to other activity. So if you want to do something on your property and you have endangered species on the property, you might want to think about checking out some of these voluntary programs. They make the harshness of the Endangered Species Act a little less. So a question. Z cuts down some trees while clearing a field. Z didn't know that there were some Indiana bats that had formed maternity colonies in the trees. Has Z violated the Endangered Species Act? What do you think? If you said yes, you are correct. Destroying those trees that are habitat for the bats, even if you didn't know it, violates the Endangered Species Act. And you could be subject to some huge penalties, both fines, civil penalties, and maybe jail time. Shifting to dumping and unsafe buildings. You cannot dump or throw litter, throw garbage, etc. That is a criminal offense. Landowners cannot maintain a garbage pile more than 50 pounds or have a salvage yard without a permit. You cannot maintain unsafe and unsanitary buildings. Excuse me. Municipalities and counties have authority to regulate unsafe and unsanitary structures on private land, but let's go back to the Right to Farm Act. In West Virginia, counties may not regulate unsafe or unsanitary structures on agricultural lands. Again, I don't think you want an unsafe or unsanitary structure on your property. It might, even though the county can't regulate it, that might cause some liability for trespassers or others, but the county can't regulate it. So keep that in mind. There are restrictions on outside burning. You can only burn waste grown on the premises or produced in the household, and you are not served by municipal or private refuse collection. You should check your local burning regulations. Make sure there's not an air pollution alert. March 1st to May 31st, and October 1st to December 31st are forest fire seasons, so be careful there. And you have civil liability for escaped fires. So if you have a fire on your property, you don't contain it, goes to another person's property, you may have liability for that. Oh, wow, now a really tough topic, water rights. And I teach a semester-long class on water rights, and that doesn't even cover it. So I can't cover it in a couple minutes here. But the key word in West Virginia for water rights is reasonable. Again, a very subjective term. For surface water, West Virginia uses riparian rights. That means if I own land that abuts a surface water, like a stream, river, or a pond, lake, I can reasonably use that water, but I'm sharing it with everybody else that abuts that stream, river, lake. I cannot take water from that stream and transport it to another property that doesn't abut it. So I can't pipe it or truck it somewhere else. Can I irrigate? It depends. It depends on whether that will interfere with other people who are riparian along that stream. So you have to look at that. Polluting the water is not reasonable, and it can be a criminal offense. Polluting the river or the water means that nobody can use it. How about groundwater? And we call it percolating groundwater because it is within the particles of the soil. It's not a stream or flowing river under the ground. If it is, surface water rules apply. If it's just water in between soil particles, it's the reasonable use rule. Sounds like riparian rights, but not exactly. For groundwater, I have the right to reasonable use, but there's no sharing. I don't have to share the water with other people. I can't transport it, just like surface water. What that no sharing rule means is, can you irrigate? If you're irrigating reasonably, yes. I don't have to say it depends. I can say yes, because if I'm using the water reasonably on my property, and I take all of the water, and the neighbors don't have any, that's reasonable. Another thing with groundwater is that a landowner has a right to lateral and subjacent support. So if I, for example, pump all of the groundwater from beneath somebody else's property and the land collapses into a sinkhole or the like, I might be liable for that. Here's a hypothetical for you on stormwater. Every time a storm occurs, water naturally drains from a roadway onto X's property, flooding the property and causing damages. So X says, I'm going to ditch this property to drain the water to protect myself. They don't intend this, but the water now drains on diseased property from the ditch and causes damage to diseased property. Is X liable? Now, the old rule in the United States was common enemy. Stormwater is a common enemy, and I can do whatever I want with it. And if it hurts somebody else, that's too bad. But what's the key word in West Virginia? Reasonable. I can take reasonable steps in light of all the circumstances. But even if I don't intend to harm somebody else, if I harm somebody else, I am probably liable. And the fact, I mean, they're going to point to it comes from the road. Doesn't matter. Once it gets on your property, you have to be reasonable. And draining it onto somebody else's property is probably not reasonable. Let's go from one really complicated topic to another one. Stream bed ownership is very complex in West Virginia, and so I'm going to double down on my disclaimer here and say, I'm going to give you the basic rules, but it's very complicated. If it is navigable water body, the landowner owns to the low water mark. The West Virginia Public Land Corporation owns between the low water marks. What does navigable mean? Gosh, I wish I could say we're out of time. It really is difficult to say what navigable means. It basically means, can that water be used for some commercial purposes? There is an individual who is gathering data on navigable water bodies in West Virginia, but the only way we know for sure if a court has ruled on it. And so you got to go court by court, case by case to see if it's navigable or not. So that means that if it's navigable, state owns the stream bed between the low water marks. That means people can float by on their boats, kayaks. They can fish, but they cannot come onto your property. And your property is between the low water marks. If it is non-navigable, West Virginia has two different categories: floatable and non-floatable. If it is floatable, the landowner owns to the middle of the stream bed if the stream is designated as a boundary. Otherwise, you have to look at the deed. Very important in these situations to do a title search, find out where the property line is. A lot of deeds, landowners are smart. A lot of times when they conveyed property, they said the stream is all on my side. So you have to check that out. But even if you own the stream bed and it's floatable, the public has the right to float. That's all. They can't step out of that boat or whatever they're floating by on. They can't fish. They can't get on the banks to picnic, but they can float. If it's non-floatable private property, people can't float, walk, fish, do anything on that property. And I'll note, even if it's navigable water body, the public does not have the right to trespass on private property to get to that navigable water body. There has to be a public access point. Now, the private rights to the stream bed are subject to the rights of the state of West Virginia, who owns the fish and wildlife. And this applies to all wildlife, and this is interesting, except fish, frogs, and other aquatic life in private ponds. So if you have a private pond, the state has no right to come onto the property to check it out. Otherwise, the state has a right to check on their fish and their wildlife so they can enter the land for certain purposes. Wildlife and hunting. Like I said, wildlife is owned by the state, except for the aquatic animals in private ponds. The state regulates hunting. If I own the land, can me and my immediate family, hunt on the land without a license? Yes, you can, but you have to follow all of the other regulations. If you want to destroy, kill deer or bear that are destroying your property, you have to get a permit to do that. So remember, unless you get a special permit, you have to follow the regulations when you're hunting, even on your property. We're going to shift again to another important topic, fences. And West Virginia has very specific regulations on fences. To be a legal fence, it has to come within this definition. And I'm not going to go through all of these. But if it's a post and rail, for example, or post and planks or pickets, it has to be 4 feet high. There's more. Tells you how many strands, how far apart the strands have to be, how far off the ground the strand has to be. And it tells you how far apart the posts must be spaced if you want to be a legal fence. Same with any other type of fence. Very detailed provisions. And that's so that you can say, I have a legal fence and I am protected if, for example, livestock break out of it. Note, in particular, electric fences. You cannot have your own homemade device to electrify a fence. It has to be a high-powered, low-impedance fence controller that complies with international safety standards. So be careful about that. There could be some liability. Partition fences are generally placed off of the boundary line, but they may be placed on the boundary if 1/2 the width is on each property. If both property owners plan to use the property for agriculture or grazing or horticulture, then each property owner is liable for 1/2 of the construction costs, repair, and maintenance costs. However, if only one landowner is going to farm, they are responsible, the other landowner is not. As in every situation, I urge people, talk to your neighbor, be a good neighbor. Fences can cause a lot of fights, and fences can cause people to not get along. And even in Virginia, there was a case where someone was killed over a fence dispute. Minerals and timber are so complicated that it would be a separate publication. But minerals and timber rights can be severed from the surface rights, so we might have different owners of the minerals versus surface, or timber versus rest of the surface. I'm just going to say you need to consult an attorney here, consult a professional forester. As for timber, and the West Virginia Land and Mineral Owners Association is a great resource for mineral ownership. Adverse possession. A lot of people are really scared that their property might be taken through adverse possession. And it is a legitimate fear, but adverse possession is very, very difficult in practice. The adverse possessor must possess the property adversely or hostilely, which means that they don't have permission. They have to actually be on the property. Their possession has to be open and notorious. So they are telling the world, I own the property. If it's kind of can't be seen from the public view, that's not open and notorious. The possession must be exclusive. They must be the only person or persons on the property. And it must be continuous for a period of at least 10 years. Must meet all of those requirements. Let's look at an example. 11 years ago, a family moved into an old rundown house located in a remote corner of Z's homestead. Z allowed them to stay as they were causing no trouble. And he knew they were there because they could not afford to live anywhere else. The family now claims ownership of the property. Who owns the property? Remember, it has to be adverse and hostile, continuous, open and notorious, actual, exclusive, at least 10 years. Do they meet the requirements of adverse possession? It's not 100% clear, but I would say that Z likely still owns the homestead because Z allowed them to do it. He gave permission. Now, Z probably should have documented that permission in some written document. That would have made it more clear. But since Z was aware of it, allowed it, probably not adverse possession. Someone can also get the right to use the property of another person through something similar to adverse possession. It's called an easement by prescription. That means, let's say it's an easement of ingress or an egress, we call that often a right-of-way. Let's say that somebody's been using your property as a driveway, right-of-way. It has to be adverse, continuous, and uninterrupted for at least 10 years. Use was actually known by the owner of the land, open, notorious, visible, and a reasonably identified portion of the property was used, and the manner or the purpose of use is clear. Again, the best way to protect yourself in these situations is to, number one, know where the boundaries are. You might have to do a survey. And if somebody is using that property, make sure that you document in writing that you prohibit them from doing that. If they continue to do that, you better stop them, or do something in writing that says, hey, I'm going to give you permission to use this until we resolve it. But make sure that you monitor your property to make sure that's not happening. You can also get an easement by necessity. Very difficult to get. That means your land is landlocked, but it has to have been part of that bigger parcel before. The parcel that needs the right of way and the parcel that you're crossing over must have been part of the same parcel, and there cannot be any reasonable access to the property. And the courts are very tough when they talk about reasonable access. That means no access. So tough, but you shouldn't be dividing property and leaving a landlocked parcel anyway. But be careful about that. Z decides to subdivide a portion of his property and sells lots. X buys a lot and soon discovers that Z forgot to provide a means of access to the newly purchased property. So Z divided the property. X bought a landlocked parcel, which X should have got a title search as well. But when X discovers that, can they get an easement by necessity? In this situation, probably yes, unless the newly purchased property is entirely bound by lands of other people, not the seller. But again, this is rare, but in this particular instance, probably yes. Shifting to eminent domain. Federal, state, and local government has the right to take private property for public use so long as they pay just compensation. That is the power of eminent domain. When the government exercises that power, it is called condemnation. They condemn your property. Public use is very broad. It can include roads, utility lines, pipelines, railroads. However, in West Virginia, the state and local government cannot take private property for the primary purpose of economic development. So they can't just take your property to redevelop it into something more profitable. Again, that can be a tough question, so it can be difficult. The key, they can involuntarily take your property. You might be forced to sell your property, but the government has to give you a fair price. Note that power companies and other public utilities hold a limited power of eminent domain and can do that as well. So, hypothetical. The state plans to reroute a section of the state highway through the homestead property to make it straighter and safer. The new route will pass through the area on which Z's house is located. Z does not want the new highway on the property and does not want to be forced to move. Can Z prevent the state from building the road where it plans to build the road? Very tough situation. They're going to tell Z, we're going to tear down your house, we're going to pay for it, but you need to move somewhere else. Can they do that? Z probably cannot prevent the state from building that road. Z is probably going to have to see their house torn down. Z is probably going to have to. So this is the point where I usually ask if there are any questions. If there are questions, you can contact me or Dee. It's been a delight talking to you today, even though virtually. And I will now turn it back over to Dee.
Yes, thank you so much, Jesse. And as Jesse said, if you do have any questions, feel free to reach out to us at West Virginia University. We will be posting this recording on our YouTube channel, along with a copy of the presentation. And as Jesse said, while this is specific to West Virginia, we're encouraging all states to look at, your state and municipality laws to see how this may apply and how it may be different in your states. So thank you very much, Jesse, and thank you all for taking time to view our video.